really a great pleasure to be here. A great group, and I very much appreciate being invited. Um, I want to talk. So, as Volker said, I've been doing merger stuff for quite a long time. I was thinking and hearing about Heike Schweitzer this morning about finding the center way versus threats on both extremes. And that's how I think of. So that's really the higher level theme for what I'm going to talk about today. And what I've been working on and thinking about lately is how can we use economics responsibly to support, let's say, merger enforcement. It's broader issues with antitrust and competition policy, but today mergers. When you have in the United States, especially the Chicago school, with a veneer of economics, taking a very anti-enforcement or laissez-faire approach, that many lawyers associate that with economics, okay? But that's not inherent, okay? On the other hand, we have powerful forces now, more political, more populist, saying we need simple rules. These economists are part of the elite. We don't want any of that. So finding the center way is what I'm about right now. And I will say this, if you think of two axes, one would be more enforcement or less enforcement. Another would be more use of economics / effects based versus something simple or structural or whatever it is that's not economics based, some other formalistic rules. There are 4 quadrants there, okay? You can have lots of economics and do it very pro-enforcement. In some sense, that's what this post-Chicago economics we've been trying to do, and now we're moving along. So this notion of linking economics to laissez-faire doesn't follow. And in fact, it doesn't work at all, okay? And many of us have, so that's the high level. Now, how does that play out in mergers? Okay, so no, not so good. Oh, there we go. I just have to push a little harder, I guess. That's the way it is with many things in life. Okay, so I chose as the topic market structure because it's so, what I really mean, concentration measures, essentially, things that look at shares and concentration. That's central to a lot of what we do in merger analysis. And how important is that? What is the basis for doing that? How does that relate to evaluating effects as distinct from just measuring shares, let's say? So that's the overall topic. So how do we use market structure actually in practice? What does the economic research really say about that? Theory and empirical work. And then I can't help but then apply that to the US merger guidelines, the recent ones. And then at the end, like, what can we offer as economists? I mean, maybe we're a mixed crowd. I understand we're not all, but what can economists offer to the lawyers, to the courts, that is not just structure, uses structure some, but uses other things that are workable and practical. Okay, so that's the framework. I'm going to start with a quote from this wonderful 1960 article by Derek Bach that maybe you know of. It's in the Harvard Law Review. The title of the article is Section 7 of the Clayton Act and the Merging of Law and Economics. This article is actually extremely influential because it affected the Philadelphia National Bank decision and some of the key decisions the Supreme Court made in merger law that have had very, half-century more of effect, fundamental effect on merger law. And part of Bach's point is, basically how are we actually going to use economics? So he writes wonderfully. So I'm going to slow down and read a little bit of it. I'm a couple other quotes to come. He's talking about how are we going to use economics in evaluating mergers. It will hardly do to dismiss the role of economics by insisting that economists complicate and confuse the issues and that judgment and common sense will suffice. We do hear that these days. So just like common sense, maybe you should apply that to, handling viruses. I don't know if they're invisible, so I guess they don't exist. Economic theory has provided us with much of what little sophistication we now possess in identifying and measuring market power and in comprehending the interdependence and its significance of large, powerful firms. Again, this is 1960. The aims and applications of Section 7, that's our merger law in the United States, are rooted in these concepts, and it would be arrogant to suppose that we could muddle through without further assistance. Very nice to the economists so far, but now comes the sentence I like most of all in this whole wonderful article. But neither can we succumb to the economists who bid us enter the jungle of all relevant factors, telling us very little of the flora and fauna that abound in its depths, but promising rather vaguely that they will do their best to lead us safely to our destination. So this problem is not new. If we're going to apply economics, how do we add enough structure so that it's just not vague and unworkable? Okay, so that's Bach, 1960. Now, still staying in that time frame, I want to say a little more about Bach and what was going on, because it's had such an impact on merger law, and so many of these ideas are still so important today. I should have said at the top, my talk is very much focused on the United States. I'll say a little about European Union, UK, but that's because I know the US so well, and I want to learn from you today, tomorrow, and in question and answer perhaps more. And I've already learned from Giorgio this morning about the European side. So that's my my confession, okay, it's US oriented, okay? So Congress, they amended the Clayton Act Section 7 to the merger law in 1950. Now, it wasn't actually, it was a significant change in some ways, but not really so much vis-a-vis horizontal mergers, except it would include stock purchases, asset purchases, as well as stock purchases. So it closed a bunch of loopholes, but did not change the fundamental operative language, which is about mergers are illegal if they may substantially lessen competition. That's our language, may substantially lessen competition. But because Congress amended the act, when the Supreme Court visited this in Brown Shoe in 1962 and then in Philadelphia National Bank in 1963, they were paying very much attention to what Congress had done in 1950. Okay, you'll see what soon enough when I'm going through all this. Okay, and Brown Shoe, the court says Congress was very concerned about the rising tide of concentration. Okay, and it was particularly, by the way, the industries that they were measuring this in were manufacturing and mining, or the sectors, I should say. Okay, they weren't really measuring other things. Okay, but that's was, this mid-20th century, manufacturing in the United States, that's the driver of so much of the economy. And mining, I guess, let's add that in. Okay. Okay, so interesting fact, not widely known, I think, but it's in this Bach article, and I've looked into this. The Congress relied, there was a 1948 study about rising concentration. And this was widely seen in Congress as showing that mergers had contributed to this, and we needed to stop that. Well, it turned out the study didn't actually show that. And the authors of the study, there was some back and forth in the academic literature, and the authors of the study then later acknowledged that it didn't show that. And so Bach writes this, again, I love his language, that the authors of the FTC report, this was Blair and Houghton, he says, sallied into that austere and exacting jousting space, the learned journal. Okay, so now it's not just talking to Congress, you got to deal with referees. Okay, and where they wrote, basically they said, if you looked at the data, recent mergers have not substantially increased concentration in manufacturing. Okay, so they basically said, if that was what people were thinking, that's not what the study showed. And then he goes on to say, well, this is interesting. Congress relied on this belief, this view, and passed this law. And now it turns out that was based on some sort of faulty information or understanding of the study. And he said, I like this too, it is but what's a court supposed to do? Congress passed this law, but it was based on this misunderstanding. He says, it is no simple thing for a court to overrule a major premise of Congress by appeal to the supervening authority of the Review of Economics and Statistics. So the law is the law. That's what we got. Okay. Now, I'm not saying there was anything wrong with that law. I don't particularly like the brown shoe decision, and Herb Hovenkamp here has criticized it quite a bit. But that focus on structure was absolutely fundamental. That it was, we don't like this rising concentration, and that's of concern. Okay, so that's the starting place. And then Philadelphia National Bank is the key decision, 1963, that establishes the structural presumption. And again, just to be clear with that, the key operative language from that decision is from the court now. We think that a merger which produces a firm controlling an undue percentage share of the relevant market and results in a significant increase in the concentration of firms in that market is so inherently likely to lessen competition inherently likely, that it must be enjoined in the absence of evidence clearly showing that the merger is not likely to have such anti-competitive effects. So you've got a structural presumption, and you have to have a clear showing to rebut. This is written by, the clerk of the time, which was Richard Posner. Okay, so he's reading the Bach article, he's reading the academic literature. And in terms of the role of the economists, it's quite strong. They're citing economists all over the place here in this decision. They have a general notion that it's better to have more sellers, which was the structure, conduct, performance view of the time. Now we know now it's one thing to look cross-sectionally. It's quite another thing to ask about the effect of a merger, but that wasn't really very well thought through or understood or widely understood at the time. So you've got a lot of language, basically, we like these markets that are less concentrated, they perform better, okay? Which we still kind of believe, but it's looser, okay? And then furthermore, they add the 30% threshold. So they say, well, I have the quote here. Anyhow, they decide, well, what's substantially increasing concentration? They say, well, it's hard to know. This is the court, but 30%, above 30%, seems like it would do it. By the way, the merger in that case they were reviewing, this bank merger, was 20% plus 15% merger. So that's what they're looking at. It was, I think, the number 2 and 4 firms, something like that. Herb, is that right? So they say 30%. This merger ends up with 35%. And they say, and they have some language about a substantial increase in concentrations required. If you think about it, the delta HHI there is 600, 20 plus 15. So that, they weren't thinking in terms of HHIs, but that was the merger. And how do they get the 30%? And again, I'm telling this because of the importance of structure and the huge role of economists in this. They quote a number of economists. They quote Kazin and Turner, who say above 20% there should be a presumption. They quote George Stigler, who also has 20%. They quote Jesse Markham with 25%. I mean, here's Stigler, quote from his article, the one they quote, the one they cite. When one firm has 40 or 50% share or more, or 2 to 5 firms have 75% more of the industry's output, competition will seldom plague the industry. Notice the way he puts that. That horrible thing of competition will probably not be present if it's concentrated enough, okay? And then, in fact, he actually goes on to say, when you have these concentrated markets, basically we're gonna have a problem no matter what we do with merger control because we got these economies of scale, but kind of we're shrugging our shoulders doing the best we can. Okay, so, so this heavy reliance on economists with structure, that's the law that's pretty much been set in place by the Supreme Court and not changed. And now we have the current agency leaders, particularly the leader of the FTC, really looking back to these decisions and saying, that's what we should be doing. And that, when that was based on the economics of the time, and turns out IO economics is involved a fair bit. So where do we left in the US right now? So before we get to the structural presumption, the case law requires defining a relevant market. Now, you obviously need a relevant market, a market if you're going to measure market shares. But the case law goes further than that. It's more structural in a sense. You have to have a relevant market in order to identify the line of commerce and the section of the country in which there's a problem. Okay. Which wouldn't be so bad if it was just saying, yeah, I think this is going to affect hospitals in the Chicago area. But, you know, maybe it's not hospitals in the Chicago area, it's in the northern part of the Chicago area. And what about clinics? And so you have to say all these things with specificity. This, of course, is a big challenge, and it trips up a lot of plaintiffs and government in many cases. Now, as I wrote I have a recent article about the 2023 merger guidelines you can find on my website. So I'm going to be drawing on that through some of my talk here. And I point out there, listen to the language that's actually in the statute. The statute prohibits asset acquisitions that may substantially lessen competition, quote, in any line of commerce, in any activity affecting commerce in any section of the country. Okay, now I, not being a lawyer, read that, I'm like, sure, sounds like they meant to include essentially everything. Any line of commerce or any business activity, let's say, or affecting commerce in any section of the country. Basically, it's inclusive. But the courts have taken that and said, oh, that means the plaintiff has to just tell us exactly what the relevant market is with all this, exactly, you know, pretty much exactly where the boundaries are. That was not meant by Congress, I'm pretty sure, to be a restriction on bringing, it was meant to be expansive. So we've got that. And then we've got, like I said, the Philadelphia National Bank case, which is very important. And Herb and I have written about this, how important it is in our 2018. It's the structural presumption has weakened somewhat over time, most notably because of this Baker Hughes decision by the DC Circuit, which rather brazenly, the Supreme Court says you have to have clear evidence to rebut. And they go, well, not so much. You know, it's, you know, you got some market share numbers. And then if there's, you know, reasonable evidence, whatever preponderance of the evidence, some lower standard for rebuttal. And that's been then picked up. And so we still have this presumption, and it's very important. Okay, it's a critical part of how we enforce mergers and horizontal mergers. I should say my talk's almost entirely about horizontal mergers. I probably should have said that at the top too. Okay, so whatever I'm saying about structure and the problems, I'm also thinking, because I'm the academic and the government, you know, former government official and the practitioner, we sure don't want to give up or weaken the structural presumption because we'd have weaker merger enforcement, which is not the direction I think we should be going. Okay, and so now we've got the neo-Brandeisians who are in the ascendance in the United States, at least, and very much emphasizing structure. And so where are we going with that? So so I've set things up now. All right. What's happened over time? The Supreme Court has not had a merger challenge for 50 years. So we get this freezing of these principles based on, it's weird if you think about it. The court looks at the economics of the 1950s and early 60s, makes some determinations based on what the economists, and then that's frozen. And then what's the impact of the economists since then, economic learning, whatever the field? Well, it's not at the Supreme Court, but there's a big impact, and it's happening through the merger guidelines. It's happening through how the DOJ and the FTC are bringing cases, explaining things. So there's lots of movements in the lower courts. Now, you might wonder what the hell's going on if you're not from the United States, especially. Why has there been no Supreme Court case? I mean, we just heard from Giorgio all the various cases with the European Court of Justice is handling them, and it's quite an evolving thing. Well, the reason is actually not that complicated. What happens in mergers is, for most mergers now, since we've had the Hart-Scott-Rodino Act in 1972 or 4 or something, it's almost all prospective mergers that are being reviewed rather than consummated mergers. Almost nobody can hold together a merger to get to the Supreme Court. It just doesn't happen. You know, the way it would have to happen would be the agency would lose at basically a consummated merger. Either they go after, they challenge if it's consummated, or they challenge it, they lose at the appeals court, the deal's closed, and the agency appeal goes up to the Supreme Court. We haven't had that. So there are routes for it to happen, I think it'll happen with a consummated merger, but the agencies in recent decades haven't wanted to go to the Supreme Court because the Supreme Court's so conservative, they're likely to make it worse. And the merging parties, the only way they'd have to go to the Supreme Court would be to have a deal where they weren't happy below, which means they can't close, and then they can't hold the deal together to go to the Supreme Court, so it collapses. So I don't know what, okay, at least for a horizontal merger. So we're kind of stuck in this cul-de-sac, or we're like, we've got this old law. I like Philadelphia National Bank decision a lot, actually. There are other decisions from the 60s that the agencies like, and they included a bunch of them in their draft merger guidelines, some of them in their final merger guidelines that aren't so strong. And there's this weird situation where everybody really knows today's Supreme Court would do something wildly different, but the old cases haven't been reversed yet. So what is the law? And this is something lawyers think about a lot, and we know a lot from the Supreme Court about non-merger cases, how they've handled them and talk about things. So there's a lot of signals there, but no actual reversal of some of their decisions. No, for example, the efficiency defense. Court didn't like the efficiency defense. There was no efficiency defense in the 60s. The neo-Brandeisians want to get rid of it. We get rid of it. Why do they have to get rid of it? Because it happened. The lower courts have it. The agencies are used to doing it, but the Supreme Court never did it. So, is it real? Is it a fantasy? What is it, right? And of course, the economists are like, well, how do you do merger analysis without considering efficiencies? I don't think you can do that anyhow. Okay. So, all right, and then it's going back to the structure theme. There's definitely less reliance on structure in the following sense. So first off, there's a heavy reliance, because every time the government goes to court for a horizontal merger, they always say it increases concentration. We get the structural presumption that burden shifts to the merging parties. They always say that for actual horizontal competitors, not for non-horizontal mergers, not for potential competition mergers, but for horizontal mergers of actual competitors. But still, there's less reliance because the courts, I read all these decisions. The courts, to varying degrees, say, well, that's nice what you said about the numbers, but I really need to see what's going to happen in the real world here. Okay. The most recent merger decision was a North Carolina hospital decision. I think Novant is the name of it, where the FTC challenged this merger, highly concentrating in some markets, in some regions of I think it's North Carolina. And the court said, yeah, these Herfindahl things are through the roof, but I think the reality is, this hospital isn't doing well. They're going to be rejuvenated with the merger, et cetera. So they kind of quickly brushed past the structural presumption found against the FTC. The parties just abandoned the deal after it was further delayed by appeals. So I'm actually trying to decide, is that a win or is that a loss for the FTC? They lost in the court decision, but the deal was later abandoned. So, but my point is, yes, they got their structural presumption with very high Herfindahls, 4,000-ish, something like that, but they still didn't win. Okay, so that's the sense in which example of which it's weaker. Okay, so then we've got to sweep through, how has structure been used over time? The merger guidelines have been the main vehicle by which new economic ideas have been brought into the process and then picked up by the courts. The district courts and the appeals courts, particularly the DC Circuit, which handled a lot of these appeals for decades, but never the Supreme Court, like I said, since they haven't been getting these cases. And just to give you sort of the sweep of this, in 1968, very much structural. The language is, we're trying to stop increasing concentration. That's the actual goal. And one of the things you have to be careful about if you read stuff from that era is people talked about concentration and lack of competition as synonymous. Okay, we distinguish now. We say, oh, well, this industry has three big players, but they're competing really hard. Or this 4-to-3 merger might be okay because these guys will get more efficient. We're distinguishing competition, substantial lessening of competition versus concentration. And people just didn't really distinguish. So when they talk about these things, they're just, it's almost like they're synonyms. And so you have to be careful reading stuff from that era. Highly structural. 82 is a big change, as you probably know, many since a lot of us are merger, folks here. Certainly the much higher thresholds, but maybe more important, introducing the hypothetical monopolist test as a way of defining markets. The other thing from the 50s and 60s, all the 60s stuff, you get very little sense that people were really worried so much about what the market was. It was kind of the market was whatever, pretty much what you could measure. They were looking at the data, here's what you could measure, and that's the market. It was kind of, just groupings of products. And so bringing in the hypothetical monopolist test and then focusing on enhanced market power rather than structure itself as the objective. Now, the draft merger guidelines from last year there was indications there that the agencies wanted to return to concentration itself as the goal, that is stopping increases in concentration and enabling deconcentration. But with pushback, they don't really see that in the finals. Okay, but that thought is still there of concentration is a priori bad, is what we're, the simplest thing we could look at and say, we don't want that. Well, it's competition, who's harder to say. Okay, plus maybe some folks think 4-3, maybe you'll have lower prices or better innovation, but I still don't want it because it's more concentrated power, dealing with non-economic issues. Okay, so 82 brings us to focus on market power, not just structure. And then when we have unilateral effects, we have entry coming in. This is the Chicago School influence now by 92, a lot more openness to entry. And this is partly, again, the influence of economists, in particular Bobby Willig, who had written about contestability. He had a big hand in those guidelines and was a big believer that entry could solve a lot of problems. And I don't think that's shown empirically, but you see that in those guidelines, and you see some influence on the law there as well as expanding the entry defense. So from my way of viewing that was influenced by economists, not in a good way, but influence. Okay. And then the efficiency defense introduced by no less than Robert Patofsky, a real lion of antitrust enforcement. Why did he do that? Because he thought that if we didn't have that, the agencies, we would look stupid. And the court's like, what are you doing here? Okay, so it was to introduce it, say we understand this, but cabin it in. So rather than ignore it and say we're not going to consider it, we'll consider it with some with a lot of skepticism. And that's pretty much persisted for 25 years. So we didn't change that in 2010. Okay, so these are so then we have the last two rounds, 2010, 23. Let me just show you a little bit of data just to remind you why the guidelines are important and what they say and how they think about these things. Just again, maybe you're all familiar with this, but it's a good refresher reminder. This is rate of second requests issued by agency by fiscal year. So the numbers are just number of second requests. And then the line here, when I've got the circle at the end, are the percent of second requests from all HSR filings. So the percent of mergers that get a second request. Okay, which is often in the 2 to 3% range. It dipped down lower the last couple of years just because there was a huge wave of mergers. The number of second requests, you can see it's, just look at the top numbers, it's 40, 50, 60 a year. Okay, so if that's 2%, out of 2,500 filings or something. Okay, so the reason I mention this is it's so critical which ones you look at for a second, which second request, which deals you choose for a second request. The other ones are going through after a 30-day waiting period. These are the ones. So if you're not doing this smartly, you're missing a lot of stuff. You're also wasting a lot of resources potentially. So that decision, we don't see a lot of that decision for the US. It's all internal, we just see what happens. But that's very much, so one key question is, how can economics help agencies make that decision. Okay. And is that a market structure thing? Is that something else? I would say it's more evidence about direct competition or worries about coordination than measuring the share, because we don't typically know what the shares are or the market is at that point, but this different cases different. Okay, so this is information at the screening stage, if you will, second request. What am I doing wrong? Oh, there we go. I think I would have hit too far. No, that's good. Okay. And then, and you can see this is by deal size. So in the left-hand column is transaction size. And the threshold's about 100 million now. For some reason, they have a few that they're getting notified below that. I don't know why, but it's a small number. This was a recent fiscal year, most recent fiscal year reported. There are 3,000 some transactions. And if you look over here, number of second requests, it's broken out between the FTC and DOJ. So we got 47. That's the 1.6% rate, which is the lowest it had been in a long time because this was a merger wave, like I said. Okay, so, and if you look at the deal size, well, look at the last couple rows. I mean, almost all these second requests are 300 million or above, but a lot of the deals are below 300 million or lower. So it's really, there's a lot of deals that are above the threshold, but below half a billion dollars that almost none of those get looked at, right? It's like tiny numbers here, less than 0.5%. So it's really critical we know there are a lot of deals that go below the thresholds that cause trouble, and there must be a bunch above the threshold. So this ability to focus resources on the second request is really important, right? So how that, then let's talk about how market structure has been handled in the more recent guidelines. So 2010 horizontal merger guidelines, as folks said, played a central role in doing that. Joe Farrell was at the FTC at the time. And like all the previous guidelines, they were basically written by the economists. Okay, that's been true since all of the previous ones. Not true in 2023. Economists had a big hand in it, particularly Susan Athey at the FTC and Aviv Nevo, Susan Athey at the DOJ and Aviv Nevo at the FTC, but not so much in control, okay, as had been the case. And what were we doing? So here was the strategy, okay? And I've said this is not some reveal, okay? I've written about this, is look, the way to win is a structural presumption, but the courts want to know what the story is. And they're also explaining how we actually analyze these things in the agencies, which is we do a lot of analysis on effects, as does DG Comp and the chief economist team, as do other jurisdictions. So we want to explain how we do that, but we also know when we go to court, this structural presumptions would be central to winning. And so the way that's going to work, we think, is given that the courts are pretty open to rebuttal, we better tell the story well. So we want to tell the story about how we analyze effects, explain that from the government side. We did a lot of that, much more than in 92, a huge change. But in terms of the structure, we want to explain why we can often have legitimately very narrow markets, and the hypothetical monopolist test can lead to very narrow markets. I didn't understand that myself 20 or 30 years ago. As we've done more work on unilateral effects, we've really come to understand that hypothetical monopolist test, I'm pretty sure Bill Baxter wasn't looking for narrow markets and high enforcement, but the test they put in place is a huge tool for the government because it leads to surprisingly narrow markets in a lot of cases, okay? Look, essentially any case where you've got a unilateral effects that would be at least 5%, the two products of the merging firm, that's a market. Okay, that just follows by logic. So that's not how people think about it. You've got a differentiated product industry with a bunch of products. You say, oh, these two products alone are a market. They're like, what are you smoking, right? So we had that to work with because the hypothetical monopolist test was widely accepted by the courts by 2010. So we wanted to use that, again, totally legitimately explain, including what we call markets for targeted customers, markets for targeted customers, which also are called price discrimination markets. Okay, and then articulating unilateral effects and how this all is an integrated way of viewing competition. So that was the move. And 10 plus 15 years of merger cases have proven that to be very successful. I have a paper with Howard Shalansky about that. Okay, so that worked really well, particularly for unilateral. Now we raised the HHI thresholds, which people look back now and say, oh, well, you were giving away a lot. That was a mistake. And it's been reversed, okay? And the reason we did it was not because economics tells us what the threshold should be. It was simply, we have this huge gap between the actual enforcement and what the guidelines say. And we thought, well, let's lower the gap by enforcing at a lower level, but also bringing the thresholds down. And that we didn't think that would hurt us in terms of enforcement because all the litigated cases were way above the 2,500 level anyhow, essentially. And Howard and I have the data on that. So, that was the strategy. In other words, to go with narrow markets, hypothetical monopolist test, and harness structural presumption while telling the story. Now, that is not the strategy of the 2023 merger guidelines. So I think I'm open-minded, okay, and I've said some nice things about them, but I do think they've made a blunder in this respect, okay? So how do they treat market structure? It's kind of schizophrenic, okay? There's a lot of emphasis on structure and thinking about structure, and they want to make the structural presumption stronger by making it just harder to rebut. Now, they can't do that on their own. That's for the courts to do, but they're trying to lead the courts in that direction. For example, with coordinated effects, say, look, if it's a concentrated market, we have a presumption there's going to be some coordination. The government, they're saying we, the government, don't have to explain how the coordination is going to work. Okay, versus in most of the previous cases, they've had to say, well, because prices are easy to observe, because the companies can respond, because of some factors make it easy to. They want to lower the bar for themselves, but rely a lot on the structural presumption. They also add a 30% threshold. So if the merged firm has more than 30%, and the delta HHI is 100, then they add that presumption. Now you say, well, what are the courts going to do with that? Well, they point to Philadelphia National Bank with the 30% number. So that's good. That's good, solid basis. The problem with them is not the 30%, it's the delta HHI of 100. Because Philadelphia National Bank, as I mentioned a little while ago, the delta HHI was 600. And the case actually has language saying how much of an increase in concentration is needed, and it's not a suggestion anywhere near 100. Not that they were talking in terms of delta HHIs, but just in terms of the shares of the merging firms. So that's a stretch for them in terms of how the courts will receive it. The other thing they've done that I am uncomfortable with is there's no safe harbors for in unconcentrated markets. Okay, so going back to 82, there's always been various language on the view that, and the Supreme Court said this in Brown Shoe and other cases, well, businesses need to know what they're allowed to do and not allowed to do to run their affairs, right? So we want to give them guidance about what sort of mergers are going to be okay. So particularly the Republican administrations, but we had this in 2010 too. Here's the sort of things that won't cause a problem, including low concentration. So that's gone, okay? And I'll come back to that in a moment when I show you the numbers. So those things make me nervous, both because are you creating a lot of uncertainty for the business community and mergers, but also because I think that could actually hurt them when they go to court to challenge the fact that there's no safe harbors. Okay, and the fundamental problem there is these guidelines are telling the world and the courts, if you've got a reasonably concentrated market and concentration increase, that's a signal that there's likely to be a problem. But if it's really unconcentrated, not informative. Well, that's kind of weird if you think about it. There's this metric that shines a red light in certain zone, but if you're out of that zone or a little below that, or way below that, it doesn't have a green light. It only has the red light. It's like, well, is this metric informative or not? So I understand logically how you could tell that story. And I think I know why they did it, but I think it's going to get them into some difficulty. And in the North Carolina case, Actually, the judge pointed out that under their approach of the FTC, even a merger with a very small hospital or health clinic hospital would trigger their guideline, would trigger a structural presumption. So the judge signaled, I don't think didn't say this, but reading between the lines, I don't think that seems very plausible to me. You've got such a low trigger that I'm going to give less weight to this whole thing. Okay, so there's just that was one judge, but that's a recent one. The other thing that worries me is, again, there's probably some pride of authorship, so I can see that as a human being, but just substantively, we did all this work. There's a lot of language in 2010, and my article goes through this to support and explain targeted markets, narrow markets, all this stuff. And there's a sentence or two in the 2023 guidelines to that effect. They definitely mention it. They haven't changed, but there's just so much less material there with examples and working it out and explaining how hypothetical monopolist test can lead to these narrow markets. I just don't think it's going to have the same impact on the courts when they're fighting over that, which is what you're often fighting over in court, where the merging parties say, no, the market's much broader and the shares are much smaller. We just had a lot of material in there to be ammunition for the government, and it's not there. We'll see over time. Maybe it won't matter. Okay, I'm worried though. And related to that, I don't know how many of these brown shoe factors. The brown shoe decision lists all these things that the courts should look at to decide the relevant market. And it's things like, what does the industry usually talk about? And who do companies track? And all sorts of things. And my experience with a lot of litigated mergers and merger investigations is the merging parties always bring in those factors to argue for a broader market. And the governments always say, no, the hypothetical monopolist test, that's what you do, the market's narrow. Now the guidelines lead with the brown shoe factors as the way to define markets. So maybe because they love the brown shoe decision, it's cited a lot. I believe the likely effect is going to be opening up for the merging companies to say, yeah, good. Yeah, let's go with these brown shoe factors. And it's going to make it harder for the government to win on it, to establish a narrow market, even when the hypothetical monopolist test points that way. And that's gives the correct read in terms of market shares and likely competitive effects. So I think that's the blunder, I think, to do that. And I think, as far as my understanding from what I read and listen to, a lot of the neo-Brandeisians hate the hypothetical monopolist test. They view it as, it's economists created and it's very quantitative and fussy and whatever, and they don't like it, and they like brown shoe. So, but I think that's not smart in terms of enforcement. And so I'm concerned. Okay, since I'm in Germany, 2 minutes on something other than the United States. We talked about the US. So I'd like to, I'm not going to say much, just to notice the differences. And then maybe we'll have a conversation about that, over dinner or in the breaks or the Q&A. Market structure, I read the 2004 EU merger guidelines as they definitely have structure there, but there's not, don't spend that long on it in a way. They kind of talk about it and then go on and talk a lot about effects. I noticed the recent guidance is all about shares and plausible markets and things like this. So it seems to be very important for screening and guidance purposes. I'm curious what you all think about how much the structural presumption or structure is driving things in the courts and at the commission now. There's that. And then in the UK, quite striking how you read their merger assessment guidelines. There's a market definition section at the end, and it's basically like, oh yeah, we're supposed to talk about, we have to define the market because that's a requirement, so we'll do that. It seems completely disconnected from the analysis of the merger. You get the sense it doesn't have anything to do with how they actually analyze the merger. It's just a box that needs to be checked, so they're going to check the box. Okay, so very different. Interesting to me. How's that working in practice? I don't know. I'd love to learn. Okay, now, what do we actually think about, what do economists think about all this now? What, 5 minutes? Okay, good. Well, I'll just say this, and I'll be quick given the timing. Maybe these are my views, but I think they're fairly widely shared. Nothing's universal, of course. An increase in concentration seems like a pretty useful thing to look at, and Volker, your recent paper with Mike Winston is fantastic in this. Everybody should read that paper who wants to see how economic theory can be used here in a practical way. So, there's always the market definition. Unilateral effects theory is well developed, and it's, again, particularly in that paper, we see the connection between market shares measures for reasonable markets and effects. And I really like using the compensated marginal cost reduction metric. How much would marginal costs have to go down to offset the bad effects? I think that's a very good thing to do. It's closely related to upward pricing pressure and stuff, but it's very clean because you don't need to know too much about the demand system, inherently. Okay. What about so we there's good basis for having some elements of structure. Thresholds, I think the notion that there'd be some threshold that's going to work across all these markets is not very well conceived, to be honest, because it depends so much on the elasticity of demand at the market level. I mean, your theory shows that, we know that, and the markets are so different as they get defined. The notion that 1800 or in a petroleum merger is going to be similar to something in emerging between accounts, I don't think that's. I mean, I understand in practice we need to do something. So I'm saying I would love to see more work on, can we different thresholds for some different sectors, or what do we know from empirical work? Hospital mergers, we have a huge number of anti-competitive hospital mergers, so we know quite a bit there. Okay, so, but the notion that, this 1800 is the right, or 2500, we don't know that. I don't think we should be seeking that as a goal of the research, because it seems to me you're looking for something, a universal constant that doesn't exist. So I just think that's, again, we should look for ways to come up with practical thresholds, but shouldn't think about it that way. And the 2023 merger guidelines, they say, we're lowering the thresholds back based on learning and experience. I'm still waiting to hear what that learning is from the research and what the experience is. I haven't heard anybody explain it, but that's what they say. Okay. And then market definition is going to be, I could spend a whole talk on that. Obviously fundamental to define before you get to structure. I'm just going to skip over it and realize it's a point. Okay. All right. This is more about the 2023 merger guidelines in general. I'll skip that. It's not so much about structure. Here's the, here just to show you and illustrate the changes in the thresholds. Might be useful for you to see this. On the horizontal axis is the post-merger HHI. Vertical axis is the change in HHI. So the change is this kind of orange zone, which used to be yellow and now became red. That's the change, really, the main change. And one of the things that happened, and it's a confession of mine if you want to think about it that way. We had this yellow zone that was meant to be, well, we could go after these mergers, but it's not green or it's not red, it's trickier. And the yellow zone became like, there's no presumption there, so it's like the green. And that wasn't the intention, but that's kind of how it played out. And so I can see moving that to red. I'd rather have that be red than green if I'm not allowed to have yellow, okay? But again, there's the question about how much difference that'll make. And then was green in 2010, meaning the language said unlikely to be a problem. So that language is eliminated. So there is no green anymore. And I've talked about that. Okay. You can't read this, but it's in my paper. The point is, if you look at the actual litigated mergers on the Biden, horizontal mergers in the Biden administration, all the HHIs are well above the levels, the thresholds, well above the thresholds from the 2010 guidelines. So ask yourself, how much difference will it make to lower the thresholds, say from 2,500 to 1,800, just to put it simply, given you're litigating cases that are 4,000, 5,000. Now I make the argument on paper, look, if the Biden folks had thought, as they say, merger enforcement's been way too lax for 25 years, then they should have at least litigated down to the, before they could change the guidelines, you litigate down to the level the guidelines say, and then you change the guidelines, and then you go further. They weren't litigating anywhere near the 2010 levels before they changed the guidelines. And there's a sliding scale, so I just don't think it's going to do very much. It doesn't. I think it's okay. It's not bad. It's just I don't think that's where we're going to get real action. But that's what the press focuses on. I don't think that's actually going to make that much difference. I think there's generally going to be costs. There's a lot of extra costs for mergers going on now. A generalized deterrence. We see whether that's a good idea or not. So I am concerned about weaker horizontal merger enforcement for the reasons I said. So let me close. What can IO economics offer here? So my program for quite a while has been to come up with simple and practical rules, not just mergers, but also in conduct cases, but mergers today again, to determine screening, whether to conduct a further investigation, whether to create presumptions, and possibly also to offer safe harbors. Okay, so it'd be guidance. So query, could any rule that's based on market structure and therefore relies on market definition really be simple? I'm not sure it can be. Okay, so that people argue about that's the great advantage of market structures. Oh, you're just looking at shares, so that's simple. We don't need to do more. Like shares of what? Unilateral effects. I have an article in 1996 about diversion ratios and margins. I think the subsequent work that's holding up pretty damn well as robust elements. We have upward pricing pressure, compensating marginal cost reduction. I would like to see that adopted more widely. I think it's practical. You could get information from merging companies' files, maybe do econometrics to do diversions. You can measure margins. That seems practical. We can try to build on that. We still need something better on coordinated effects. Okay, it's a plead. Okay, I'm too old to do that now, but many of you are not, I hope. Happy to advise, or maybe something completely different based on what we're learning, based on merger retrospectives. This is more of a challenge for the research community, but I think the goal should be simple and practical rules. We're certainly going to stick with market structure, but we can do more than that, do more and do better. Thank you.